Welcome everybody to our No Fault Divorce webinar today. We're thrilled that you're able to join us. We thought it would be appropriate to start off by just saying a few words about the situation in Ukraine. Many of us have family, friends and colleagues who are there, and our thoughts and prayers go out to them. We stand united with Ukraine in their fight for freedom and democracy. So welcome everybody. Welcome to the first in our new series of webinars, and what better way to start than a celebration of the introduction of no fault divorce in England and Wales. The discussion will focus on the political and the philosophical rather than the procedural. How do the aspirations of the new legislation compare with the experience of lawyers across the other jurisdictions? Will the new law really remove the blame game? Now we've got the Q&A function there, so if anybody's got any questions at any point, please feel free to just put them in the Q&A, and I'll try and pick them up at the end if we've got time. To start off with, I just wanted to say there have been a few changes to our panelists, and we're absolutely gutted that Nigel Shepherd can't be with us today. He had a minor operation yesterday and as a consequence isn't able to be here. And so I want to really do this webinar in his honour, because he is Mr. No Fault Divorce. It's really him who has championed this and campaigned for no fault divorce for over 30 years. As you probably know, Nigel is the former head of family law at Mills and Reeve and is now a consultant focusing on his work as a financial arbitrator and on various projects. In 2019, he received the prestigious John Cornwall Award for Outstanding Contribution to Family Law. And we are very sorry, Nigel, that you can't be with us today. But Tim Whitney has really very ably stepped into the breach, and he's here with us. Now, Tim is a principal associate in our team here in London. He's head of our international group, and so he coordinates all the people like me to do these sorts of webinars. So thank you very much for doing that, Tim. He's a brilliant lawyer, a fabulous mediator, and in all of the directories is referred to as a rising star, and I second that. So thanks very much for jumping in and doing that, Tim. And also to Camille Anger, who is a partner of Isabelle, who was meant to be speaking today. Now, Isabelle's been called away to a really important client meeting, so she can't be with us. But Camille is a partner in the International Family Law Department at BWG. She's been there for 10 years, was recently promoted partner. She specialises in international private law and in financial matters, particularly when they involve business assets and complex income structures. She's trained in collaborative law and is a member of IEJA, the French-American Bar Association. She works in English and in French. And then just Anna, who also works at Mills and Reeve, Anna T, as I call her affectionately. Anna, tell us your surname, please.
Tarasiewicz.
Tarasiewicz. Anna is a solicitor and mediator in the family and children team at M&R, advising on all aspects of relationship breakdown. Ania has experience in complex cases with businesses, particularly in the agri-business and property sector, as well as difficult child law cases involving mental health issues. Ania is a fluent Polish speaker, actively involved in the Anglo-Polish community in the UK and in Poland, and advises on cases with a Polish element. And last but not least, and thank God he's arrived all the way from Australia and in his wine cellar as usual, Geoff Wilson. Geoff, thank goodness you're here. Partner at Hopgood Ganim Lawyers, a commercial law firm based in Brisbane and Perth in Australia. He heads its family law team and is lead partner of its private client team. Geoff is an accredited family law specialist and arbitrator. He's a fellow of the IFL, president-elect of its Asia Pacific chapter, and he co-chairs its dispute resolution committee with me. Since 2015, Geoff has been ranked as preeminent in Doyle's Guide to Leading Australian Family Lawyers, and for the past 35 years, Geoff has practiced as a family lawyer under a no-fault system. So it's going to be fascinating to hear what all of our panelists have got to say. And I'd like to start off with you, Tim, otherwise known as Nigel for these purposes. Can you please start off with a brief history lesson? How did we get here in England and Wales?
Yeah, thanks, Sam. So I have to start with a huge thank you to Nigel, both for his tireless campaigning over the past 30 years, but also for preparing the notes for this webinar. So prior to 1858, divorce could only be granted through an Act of Parliament. This was hugely expensive and only available to the very rich. Jane Addison divorced her husband Edward in 1801. Jane was the first woman and one of only 4 to ever use the parliamentary process to divorce her husband. Those of you that are interested, Edward had committed adultery with Jane's older sister, and the divorce probably cost her £20,000 in today's money. Modern divorce law dealt with through the courts started in 1858, the Matrimonial Causes Act 1857, which allowed divorce based on adultery only, and this was largely only available to men. From 1923, divorce became more accessible to women, and in 1937, the law was changed to extend the grounds to include desertion, cruelty, and incurable unsoundness of mind. It was not until 1966, the year football came home, that a group set up by the Archbishop of Canterbury recommended an entirely new no-fault framework for divorce. The Law Commission took this idea forward, and although it didn't go as far as removing the fault-based grounds, it did for the first time include separation, including 2 years separation with consent. This then led to the Divorce Reform Act of 1969, which was consolidated into the Matrimonial Causes Act 1973. And this provides the system in place today. So that's the sole ground for divorce is irretrievable breakdown of the marriage, and that has to be established by proving one or more of the 5 facts. These are adultery, behaviour, desertion for 2 years, separation for 2 years with consent, and separation for 5 years where there's no consent. So in 1990, the Law Commission looked at this again and recommended a new process that removed the fault grounds completely and replaced them with a simple period of what was called reflection and consideration. The main architect of that report was Professor Brenda Hoggett, as she was then, who's better known as Lady Hale, the former president of the Supreme Court. The Conservative government decided that to act on the report, and they introduced a bill. This was all pretty controversial at the time. The government had a very small majority and was faced with a rebellion from a number of MPs who, echoing the historical objections, argued that removing fault would devalue the institution of marriage and would lead to a total breakdown of family life. They were supported by the right-wing press, who resorted to personal attacks on Lady Hale and the Lord Chancellor. The Labour Party broadly supported the reforms, but used it as a political stick to beat the government with. However, notwithstanding the furore, the bill got put on the statute book in July 1996 in the form of the Family Law Act, but was never implemented. In 1997, the new Labour government under Tony Blair came to power, and unfortunately for various reasons, including the need to appease the rebels and research that suggested it wasn't going to save any money on the legal aid budget, the Lord Chancellor mothballed the Act and it was completely repealed in 2014. This all happened during Nigel's first stint as National Chair of Resolution. I think at the same time I was enjoying an equally successful stint as monitor at school. But happily, that wasn't the end of the story. Resolution never gave up on no-fault divorce. It remained a key campaign priority for the organisation and for Nigel personally. He returned as Resolution Chair in 2016, determined to finish what he'd started. Apart from the ongoing campaigning, there were 2 other major factors in finally persuading the government that this was the right time to bring reform. The first was the excellent research of Professor Liz Trinder at Exeter University and her team called Finding Fault. This was the first major research since the late 1980s, and it demonstrated clearly that the fault-based system was legally and intellectually dishonest. This is because nearly all divorces are uncontested, and in practice, there's no actual investigation into the allegations that are being made. The vast majority of couples rely on fault-based options because they don't want to wait the minimum 2 years separation period. And more importantly, the report concluded that our current process is damaging because it raises the temperature and makes it more difficult for couples to agree arrangements for their finances and for the children. The second trigger was the case of Teenie and Hugh Owens. And they separated in 2015. Teenie issued divorce proceedings based on Hugh's behaviour. He defended it, and unusually it went to trial. The judge ruled under the current law, Teenie hadn't proved that Hugh's behaviour was such that she couldn't be expected to live with him, even though it was clear she was never going to return and the marriage was over. Teenie appealed unsuccessfully to the Court of Appeal and then the Supreme Court, who both acknowledged the obvious nonsensical approach, but said it was for Parliament to change the law and not the court. So despite the marriage clearly being over, Mrs. Owens was forced to wait until February 2020 before she was able to start proceedings based on 5 years separation. And so the combination of the adverse public reaction to the Owens case and the authoritative findings of the finding fault research, the government were finally persuaded to act. There was a public consultation which was overwhelmingly supported, and in April 2019, the Justice Secretary confirmed the government would bring forward legislation. And unlike in 1996, the bill proceeded with almost no real opposition, and the Act received royal assent in June 2020. So from the 6th of April, the sort of headline changes are that divorce is still going to be based on an irretrievable breakdown of the marriage, but this now only needs to be evidenced by a simple statement of breakdown, and there needs to be a minimum waiting period of 26 weeks before any final divorce order. For the first time, it's going to be possible for couples to make joint applications. The language has changed, so we're now talking about divorce orders and applications rather than decree nisi, decree absolute, and divorce petitions. The new rules anticipate email service being the default method. And apart from very limited grounds on jurisdiction, the validity of the marriage, or exceptional circumstances such as fraud, it's no longer going to be possible to defend a divorce. These would be called disputed cases now anyway. But this basically recognises that where one spouse, like Mrs. Owens, genuinely believes the marriage is over and remains of that view 6 months later, then the marriage is over. So that brings us up to date. You're on mute, Suzanne.
That's the first time I've ever done that. So why is this change to the law so important for clients and for lawyers? And what do you hope the impact will be?
So a good starting point is a quote from David Cork's foreword, who was the Justice Secretary at the time. So he said, allegations about conduct needlessly rake up the past. They can pit one parent against the other. Not only does this go against the grain of wider family law, but it also undermines the constructive approach that practitioners take every day to help families resolve their disputes. When a marriage is broken down, the law should not frustrate achieving better outcomes, especially for children. And I think these are the sentiments that are at the heart of our approach to family dispute resolvers. And we've all waited a long time, especially Nigel, for this sea change. I think the blame only exacerbates the problems and the conflicts that are inherent within an already difficult process. It's made worse by the fact that often the divorce petition is the first thing clients have to deal with. So talk about getting off on the wrong foot. You're having to attribute blame at the beginning, even if you don't really want to, for a lot of clients. So I think at last this gives us a process that means we can help reduce conflict and help clients and their children find the best way through divorce. This isn't going to remove blame from all divorce, but I think it should at least allow clients to start from a position of neutrality, and then allow lawyers to guide them into a more positive process rather than having to start by finding fault at the very beginning.
And were there any additional changes to the legislation you or your alter ego, Nigel, would have liked to have seen?
Well, unfortunately, this is where my alter ego's notes ended, so he didn't answer this question. But I think my answer would have been interesting to look at the absolute bar of petitioning for the fact you have to wait 12 months from the marriage before you can petition for a divorce. I think that feels odd in this day and age, given that you need to give 29 days notice before you get married. It seems strange that you then have to wait 12 months to get divorced. So I'm surprised that has lasted, but I don't know what Nigel would say.
Thank you very much, Tim, and thank you for doing that so ably. And now we go to Camille, who's our correspondent, as it were, in Paris. Camille, You also have had some recent changes in France. Can you explain these, please, and explain what options clients now have in France? And you're currently on mute, so you just need to unmute yourself.
I'm there. Please let me answer the question starting from the end. In France, the no-fault divorce is an old love story. It was introduced in 1975, and since then, the spouses can divorce on 4 grounds, which is therefore a little different from England, according to my understanding. The first option is the acceptance of breakdown of marriage, when spouses agree to divorce without seeking a grievance, but they disagree on the consequences. So they petition the judge jointly, who then rules all the consequences of the divorce. The second option is the marital bond is considered permanently altered after a year of separation. This is a new timeline which was introduced in 2019. Therefore, it was 2 years of separation. And the third option is the divorce by mutual consent, which exists in France for a long time. But in 2017, there was a small revolution in family law in France. Indeed, the divorce by mutual consent is henceforth without needing to go to a judge to approve the agreement. The spouses negotiate with their respective lawyers and find an agreement on all the consequences of the divorce, both financially and for children. And this agreement is then registered at the notary's office to make the divorce legal. This new provision has considerably reduced the delays since once the agreement has been reached, it is simply necessary to serve a cooling off period of 15 days before being able to sign the divorce. But this doesn't mean that the divorce on the ground of the fault has disappeared in France. Indeed, the spouses can still petition the judge where the other spouse has repeatedly violated his duty and or obligation pertaining to the marriage, like adultery, domestic violence, etc.
So has the recent change in the law has removed the financial impact of fault, but clients still have the choice between the fault and the non-fault system.
Yes.
Are many clients still choosing to petition based on fault? And if so, why?
This is a moderately recent change since dates back to 2009. Indeed, since 2009, the financial consequences of the divorce are completely separated from the fault committed by one of the spouses. Before that, if the divorce was pronounced to the exclusive fault of a spouse, this spouse could be deprived of maintenance. Since there are less and less divorce on the ground of the fault, and for me there are 2 factors which explain this drop. Probably the first one is the lack of economic attractiveness. And but above all, this is easily explained if only because the delays are reduced in a non-fault divorce. And for example, divorce for alteration of the marital bond is about 1 year, and even more so in a divorce by mutual consent without the interference of a judge I just talked about.
Okay, we couldn't really have an international discussion without mentioning the B word, the Brexit word, which honestly seems to have receded with all the other things that are happening in the world. Now that the dust has settled, what are the main impacts of Brexit do you see from a French perspective?
I would say the main impact of Brexit is that it has put back on the front of the jurisdiction race and decision race. Let me explain it more clearly. where the UK is seized by one spouse first, then France will automatically decline its competence on the ground of lispondence. However, because the UK is no longer bound in the EU regulation and the Bruxelles 2 bis, it can decide with the forum non-convenience doctrine that it is competent even though France has been seized first. And this will lead to parallel proceedings and a decision race. I need to remind to everybody that contrary to the UK procedure, in France, the divorce judge rules all the divorce itself, the financial consequences and the children arrangement at the same time. Thus, if this new English no-fault system reduce the delays to have a divorce decision, which could potentially leave France in weaker position, shall we say, in the decision race.
Yeah, that's really interesting. I mean, I'm not entirely sure that the no-fault divorce will, in fact, reduce the time frame, because even our old fault-based divorce system, the divorce itself was very quick. It was typically the financial and the children matters that took a long time to resolve. But I think you've raised a very interesting point there. There's another point that just absolutely fascinates me about France, and that's the interaction between client confidentiality and the lawyer's role as officers of the court. I just wondered if we could have a brief word about that, please, because it's very different to the position in England. So if you could mention that.
Yeah, the French confidentiality system is completely different to the English one, absolutely. For starters, the principle of the UK is the full disclosure, except for what is marked without prejudice.
Yes.
And in France, it's completely the opposite. Everything is confidential unless marked as official. The French lawyers are only bound by what the client tells us, and what they have agreed to share with the other side and with the judge. Of course, an equilibrium between client attorney confidentiality and the good faith of the negotiations needs to be found. And that's why when a client has negotiated in bad faith, the financial consequences of the divorce can be revised. In my opinion, the French lawyers are more flexible with what information to share with the other side than the English lawyer, definitely.
Yeah, that's a very, very different way of dealing with things than the way we deal with them in England and Wales. So thank you for that summary of what's happening in France, really helpful. And I'm now going to turn to Australia and Geoff. I feel as though England and Wales are always playing catch up with Australia. Can you please start by giving us a summary of the position in Australia and how long you've had no-fault divorce?
Thanks, Suzanne. To a point, we travelled the same journey, and that was probably until about 1974. And up until that point in time, our legislation very much mirrored your legislation when it came to divorce, and probably mirrored your legislation up until April this year. We had divorce on the basis of 14 grounds, and only one of those grounds was in respect of separation for a period of 5 years. Then in 1974, the then Labor government with Prime Minister Gough Whitlam and Attorney General Lionel Murphy, who later became a family court judge and a high court judge, introduced what was then landmark legislation in our Family Law Act. It introduced the Superior Court of the Family Court of Australia, which was a single court dedicated to family law. But the centrepiece of that legislation was the no-fault divorce legislation. And essentially, that legislation introduced what we have today, namely only one ground for an application for divorce, namely divorce on the grounds of irretrievable breakdown of marriage, and that is proven by 12-month separation prior to the filing of an application. All other grounds gave way, so there was no need to establish any fault whatsoever. And a lot of the games and fun that lawyers had and private eyes had up until that point in time went away. The process has evolved or devolved, whichever way you look at it. From in the early days, judges at the court ran divorce lists. Today, essentially, it's just a registrar with a administrative quasi-judicial function who hears and determines the divorce applications. We have the ability to have sole or joint applications like you're about to. The terminology is very similar to the terminology that you're about to embrace. We previously had decree nisi and decree absolutes. We use divorce orders now. The proceedings are commenced by application. Services, in terms of the application, there's only a couple of things that you really need to do. It's fairly straightforward. In fact, litigants in person are encouraged to do the application, and they do it online these days, and the phenomenon of divorce by post is a reality. But service is important. The respondent has to have at least 28 days before the hearing to be able to file a response if they want to. In international or overseas matters, you require 56 days. So there's a bit of a difference between your legislation and ours in that regard. So how long have we had it for? 47 years. It's taken you a while to catch up to us in that regard.
I always love saying that to you, Nigel, because I know that will be your response. You've heard about the changes that we're about to make. Do you think that we could have gone further? Is there anything more we should have done?
I've read a bit about the concerns around the service aspect and the fact that the application could be held up and games could be played and people misled, respondents misled, and the fairness about that. But apart from that, no, I think you've got it right. If there's any concern about the Australian legislation, and probably the affliction of 47 years has a lot to do with that, when they put the legislation together, obviously issues concerning family violence, conduct, etc., that are of real concern today weren't at the front of mind at the time, apart from the blame associated with the fault grounds. So that is a matter, particularly having to wait the 12 months that we do. You don't have that problem. 26 weeks, you can get an order theoretically. I think in some cases, we're inflexible, that would be of benefit to us. But yeah, no, I don't think there's too much that you've got wrong there.
And do you think you might change any of those things to sort of come more into line with what we've just recently done, or not really?
That would be making an admission, wouldn't it?
It would be.
Look, since 75, 76, there's still ongoing criticism. You can never get it right. You're always going to upset elements of the community. It's not a one fit for all scenario. We've had ongoing, as no doubt you have, ongoing commissions and inquiries into the legislation. We've just come out of two major ones. The Australian Law Reform Commission in 2019 did a total review of our legislation, and then the government said it's enough for the lawyers to do that. Now let's look at the real people, and they did an inquiry in the Senate, interviewing normal litigants, etc., and getting their stories. So there's a lot of talk about it. Whether change is going to happen is another thing. I don't think so.
And you've also heard Tim's predictions on how he thinks this will positively impact a client's experience of divorce. Do you think that's accurate? Does removing blame really help clients?
Blame is only one part of that makes up our clients. There's always, people come to proceedings with a whole lot of baggage and the like. And it just, we had discussion earlier in the week, and when we're talking with Isabelle, one thing she said resonated with me was the fact that some people just need to tell their story, and taking away that opportunity. And there's certainly not a forum there for them to be raising conduct issues. We're in a no-fault system, but that doesn't make them satisfied with the process. And really that's where we get a lot of the agitation. People want to blame the system, they want to blame the lawyers, they won't blame themselves for their own faults, but they still need to get it off their chest, so to speak, and air the dirty laundry, particularly if they feel aggrieved by the actions of the spouse, if they see themselves as the victim. I must say, an experience that we have had is, even though we have no issues of conduct, particularly in our financial remedies or in our divorce proceedings, obviously parenting is a separate issue where it is prominent and injunctions for personal protection, etc. But there is that permeation of conduct and this constant attempt to try and bring issues into our property settlement and maintenance proceedings. The courts resisted that, but it still is a major issue, unfortunately, for a lot of people, and it bugs the court no end.
Mm-hmm. There is another area that you and I have often discussed where Australia is definitely ahead of the game as far as we're concerned, and that's in relation to unmarried couples. Can you talk to us briefly about de facto relationships and the impact that this has had on clients' attitudes to living together and more generally?
Sure. Under Australian law, probably best put it that essentially there's no real difference as the law treats a married spouse to a de facto spouse, and that's been the case since 2009. Previously, the de facto financial matters were dealt with by the various states and territories. They, apart from Western Australia, referred their powers to the Commonwealth Government, and legislation, or the Family Law Act, was amended to cover de facto relationships, and essentially property settlement, maintenance, superannuation, splitting orders, financial agreements apply to de facto relationships in exactly the same way as they do to marital spouses. The only real differences are the limitation periods, whereas for a married spouse, you have 12 months from the divorce to have commenced property settlement or spousal maintenance proceedings if you haven't already resolved those issues. And I should pause there and say there is obviously a difference between our jurisdiction and others. Divorce is just a standalone application. If you want financial relief, it's got nothing to do with the divorce. You bring a separate application. So that there's that limitation period. For de factos, it's a 2-year period from separation. Now, the litigation around de facto relationships is principally in relation to when did the relationship start, when did it end. We don't have marriage certificates and divorce decrees or orders to establish that. So that's where the focus generally is. And we have a definition of what a de facto relationship is, what are the various elements, which is very much in line with common law definitions. Yeah.
Thanks so much. That's certainly, I think, our next area for reform, something that we're going to be looking at very closely. And as always, just following you in Australia. So thank you very much. And now just moving to Poland and Ania. Ania, I understand that Poland has had a no-fault option for even longer than France. What option do clients have?
Yeah, so that's an interesting revelation from our discussions and with our panelists. So the Polish law, divorce law, is regulated by the Polish Family and Guardianship Code. That came into force in 1965, so 1st of Jan 1965, and since then it was always possible to have no-fault divorce. and it could last, you could get divorced in 3 months, say. So there's no statutory time limit for waiting until you can get divorced, which is still different to England. So it's been around for a very long time. In terms of what options clients have, so similar to what we've heard from our other panelists, there is in Poland only one ground for divorce, which is the complete and irretrievable breakdown of the marriage. But it must be a complete and fundamental breakdown of 3 elements, so the emotional, physical, and economical breakdown between the parties. In terms of the options of what clients can have, quite interestingly, the divorce can't be granted solely just because 2 people want to. So the court actually is the final arbitrator of making the divorce decision. And as part of that, the court must determine whether there has been this irretrievable breakdown by hearing both parties. So there will be a hearing where both parties have to attend, and they can call witnesses. There's no limit to the number of witnesses, but each party can have 3, 5 witnesses. They can't be minor children, but anyone over the age of 17. So you could have your mother-in-law standing in court, you could have your siblings. And the court needs to look at the fault of the breakdown of the marriage, unless both parties agree that the court must not look at the fault. So essentially there's 3 options in Poland for clients. One, that neither party was at fault of the irretrievable breakdown. One of them was at fault, or that both of them were at fault. And one of the differentiating factors maybe from the other jurisdictions is that there is still financial consequences on that determination of fault.
So that's quite interesting that Poland has retained that link between fault and finances.
Yeah.
How does this impact the number of clients who rely on fault-based petitions, do you think?
So statistically, 74% of divorces are based on no-fault divorce. So the vast majority of cases are no-fault divorce. In terms of exclusive guilt of one party, which does tend to be in relation to the exclusive guilt on the basis of a man's guilt of breakdown of marriage, is about 18%.
Wow, okay. And do you have a sense of what Polish family lawyers think of the new changes in England and Wales?
I do. Having spoken to Polish practitioners, I think there is a divide. I think some practitioners like the English system of not having to actually go to court at all in terms of a divorce. Some Polish people actually actively say England has you can get divorced by the comfort of your own sofa. Others see it as that we're cutting off the branch that we sit on because of this element that one needs to go to court, even if there is no fault determined. But there is this element of faults, and it does have an impact on, it only really has an impact though in terms of finances on spousal maintenance. So whether spousal maintenance paid and for how long. So when there's no fault, then spousal maintenance is only limited to if either party are in poverty, so basic needs, and that's also only limited to 5 years. But interestingly, it's both the obligation to pay maintenance and the obligation to and the entitlement to receive. There also needs to be an exclusive guilt on one party in order to get the enhanced maintenance, which is very interesting. So the court needs to find that one person was 100% guilty, and in order to get maintenance, that the innocent spouse has been significantly affected because of the divorce. So there's 2 elements of that. So what it requires, though, where the battle essentially lies, is the person who's accused of guilt is trying to prove to the judge that there was even a 5% guilt on the other party in order not to have that maintenance. If that is the situation, say what the court say, one spouse is guilty 95%, the other is guilty 5%, what that happens in terms of spousal maintenance is that it is still payable. There is no basis in terms of poverty. There is a basis in terms of poverty. So it's still the minimum amount of maintenance, but fundamentally there's no time limit. So ultimately the obligation to pay spousal maintenance can last until the death of either party or remarriage.
Wow, gosh, that is a very unusual sort of situation. That sort of attribution of percentage blame, quite tricky, I think, to imagine. So we've heard really different things from our various panelists. I wonder if they would all now come off mute, because I've just got a few questions. We've got some questions in the box. First of all, and I don't mind whoever wants to answer this first, is eradicating fault completely from the process a positive step, or is that going too far? When could a fault-based divorce petition be helpful? I mean, I think Geoff has touched on that, but I just wondered, Geoff, if you had any further thoughts in relation to that, and then anybody else.
Yeah, look, only that it can be a cathartic process for the individual. So it's therapeutic in that regard. And enables them to tell their story. I don't know how helpful that is ultimately, and maybe they should look outside the forum of the court to address those issues.
And so do you have mandatory therapy in Australia?
No, we don't. I mean, it's the legislation when it was framed was trumpeted for its approaches to counselling and the like, but it's a voluntary process in that regard. And certainly as practitioners, we encourage our clients to get whatever therapeutic assistance they can get to manage the process and the breakdown of the relationship. But yeah, apart from that, no, I see the positives, having lived through it, and it becomes quite a routine process. And whilst it is emotionally probably the most significant event in terms of the end of their relationship, compared to the other applications they have to deal with, it's quite pedestrian.
Thank you. Does any of the other panelists want to add anything to that point?
Do you want the French opinion?
Yes, please.
From France, the no-fault divorce is of course a positive step, because it is in France, it shortens the delays for one, and also because it keeps the divorce purely factual. But in some case, it seems to me that cathartic alternative is needed. Indeed, when the lawyer is the only person that knows all the resent and hurt of the client, and then those questions are sometimes central to the case, completely ignoring them in the debate could prevent a real resolution of the conflict. The eventual grudges could spill over on financial proceedings, and even more likely the children proceedings. And it is the lawyer's responsibility to deal with those issues to make sure they are resolved. In my opinion, in a completely no-fault divorce system like in England, it is important to advocate for alternative dispute resolution, such in France we know the mediation or collaborative law, to try and purge those issues.
Yeah, no, I totally agree, and I think it's going to be interesting to see how that plays out. I don't know if anybody else is obsessed by the TV program Couples Therapy, but I think that sort of therapeutic work that we're hoping that people will have, and that's an appropriate place for them to sort of discuss any of the fault that they need to sort of move on properly in relation to a divorce. I think it's something we may see. Any other comments before we move on to the next question?
I think just I agree with those points, and I think that the fact that fault has no impact on the proceedings in England, it's slightly disingenuous to allow people to start a process that has fault in it when there's going to be no effect and no one's going to look at it. So I think that it's logical and it's right that it should be the only option. I agree with what Geoff and Ian saying about clients will need an outlet, and I think that obligation will fall onto lawyers to work harder, maybe with clients, to move them towards therapists and other professionals that can support them, so that there's the ability to process the feelings, the anger, the frustration, and potentially mediation being a good option to be able to let the parties have some acknowledgement over that, those types of feelings, to allow cases to move forward. But I think that ultimately the court was never the right place for that, and so it's right that it's no longer an option. But I think we will have to look at how it's replaced.
Thank you very much. And question 2, the new system has kept the 12-month bar before you can actually petition for divorce. Should there be a restriction as to when you can start proceedings? Any thoughts there?
I'll go. I'm happy to go first.
Yeah.
I don't think there should be. I think that either there should be a discretion or there shouldn't be a time limit. As I mentioned earlier, it feels odd that people can get married within 29 days and then have to wait 12 months to get divorced. I'm sure there are situations that, if domestic violence or controlling coercive behaviour, why shouldn't people be able to get divorced quickly if things have just not turned out to be what they expected? And I think there's less serious examples of people just making mistakes, and they should be able to remedy those. So I don't see that it's needed. And if you could have had an option that there was a discretion, and you could give reasons why that bar wouldn't be absolute. Yeah,
thank you. Camille.
Yes, in France there is no bar as to when you can petition for divorce. That means a spouse can start the divorce proceeding just the day after the wedding. This is the honeymoon divorce.
Didn't Britney Spears do that?
Yeah. And I will tell you an anecdote. If during the honeymoon the wife had an affair with the nice golf teacher, true story, in France the husband should be entitled to get a divorce as soon as he gets back in France.
Wow. Okay, well, I must stop my golf lessons. Ania, did you have any comments in relation to that?
Only the same as Camille. Poland, I mean, its divorce laws were brought in 1964, and it never required a period of waiting. So it's interesting that actually England seems to be quite behind in that regard.
Okay. And my third question, what are the grounds for defending a divorce now in England and Wales? How does this compare to the no-fault system in Australia? So, Tim.
So it's very limited. They're now disputed cases rather than defended cases, but essentially it's procedural. So arguments around whether the court actually have jurisdiction, or arguments about the validity of marriage, and then it would be exceptional circumstances, fraud or something like that. There's not the ability to defend in the same way that there was, in the same way that Hugh Owens did, so that's all gone now.
Okay, and what about your thoughts on that, Geoff, in terms of no fault?
Yeah, the situation we have, obviously the jurisdictional aspects of it, because we have a time frame of 12 months, if you want to defend, you'll argue that you haven't been separated for 12 months. That's a sort of short-lived argument. I've had a couple of applications that have gone to a contested trial and stupid money's been spent on that. The practical way of dealing with that is you just withdraw your application and you bring your application after the date the respondent says separation occurred. There's one aspect of the making of a divorce order under Australian law which could prevent the making of an order, and that is apart from finding the ground of irretrievable breakdown of marriage, the court also has to make a declaration that it is satisfied that in all the circumstances there are proper arrangements for the welfare of the child. So it may be a focus of a response or for defence to say that there are no proper arrangements or the arrangements don't satisfy that threshold, which could hold up the making of the order. But there is also a let-out valve that the court might be satisfied on reasonable grounds as to why it should make the declaration, even though it may be not satisfied there are proper arrangements.
That's great. Thank you, panelists. Now, there are a couple of comments and questions in the chat box. I'm just going to read through some of those quickly and see if we can answer them. And interestingly, Christopher Arnold has said, Canada has the same choice. Nobody chooses fault. Instead, 99.9% choose living separate and apart for at least a year. So that's interesting to hear about Canada. We've got somebody asking, do you expect a flurry of divorces from people who have not reached their 2 or 5 year separation yet? What do you think, Tim?
I don't think we will. I think there's ultimately people in those positions would often be persuaded to use behaviour, which is why the numbers of behaviour are sort of disproportionately large. But I don't think there will be a flurry. There may well be, and I'm sure as family lawyers we wouldn't necessarily reject that. But I think what's probably more likely is you'll get people that are thinking about getting divorced and separating now who will wait because they would prefer to start off on a nicer footing if they can and if the circumstances of their case allow. But I'm not expecting my inbox to sort of go mad.
Yes, I think it's quite interesting at the moment, people deciding whether or not to wait to issue on a no-fault basis. And it's only recently, probably in the last week, that all the forms have been released by the Ministry of Justice. So we're all getting to grips with them at the moment. Tasha Bevan-Stewart has said, I agree, mediation or collaborative can help with bearing witness to each party's experience and helping them to tell their story. And I'm sure we agree with that. Now, there are 2 questions here that I think are saying the same thing. That's Jenny Craig and also Michael Brennan. And basically the question is, do you think that no fault may increase the use of conduct in financial remedies work?
I think that's a good question. And I think that the answer is that it shouldn't, because the conduct in financial remedies is relatively clear in case law as to what is relevant and what isn't, and should be very different to what used to be included in a behaviour petition. It has to be it has to have relevance to the finances. But I think that only time will tell as to whether clients feel so strongly that they want to put their side somewhere. And I think that goes back to my point earlier as to that it's the lawyer's job to try and help direct it in the right way, because it won't help a judge sitting in the first appointment in the finances to have a long annex to a Form E saying about why the relationship broke down and whose fault it was. But I think that's an interesting question. I think it's a good point to raise.
Any comments from any of the other panelists? Geoff?
It's certainly been the experience in Australia that there is attempts to raise conduct in the financial matters. The courts set out clear guidelines as to when it will and won't accept the evidence. There's a decision, the leading case of Cannon in 97, where the court said it was never going to open the floodgates on it, but if the conduct relates to contribution, which is the primary basis upon which we make property settlement determinations, if you can show the conduct somehow impacted on the contribution, they will allow it. But prima facie evidence of, for instance, family violence of itself is not a basis. So it constantly gets recycled. I mean, that was 97. We still have a number of cases even into this year where the court has had to clarify that principle. But it depends, the judge has a discretion as to how far they'll allow it, and attempts are made. It's typically done more so by clients with inexperienced practitioners or self-represented litigants. They jamlog the court with totally irrelevant evidence, which no doubt frustrates the judges, but it happens. And I think it's because of that very fact that it's an outlet for them to have a say.
Thank you. And I just wanted to finish, if I might, with a comment from Karen Botha, who's an attorney mediator. She says, it's so interesting hearing the various views. South Africa has a no-fault divorce system, but when summons are issued, we still include the reasons for the breakdown. In my experience, the no-fault system has not reduced the acrimony or length of litigation. So I think it's really interesting to have heard from so many different views across the world. I really would like to take this opportunity of thanking my panelists. So thank you, Tim, Camille, Ania and Geoff. Obviously, saying as well, thank you to Nigel for all of the work that he's done in the campaigning. So sorry he can't be with us. And there will be a feedback form that will come up immediately after this webinar is finished. If you could complete that, we'd be really grateful. And as I said at the beginning, thoughts very much with our family, friends and colleagues in Ukraine. We stand with Ukraine. Thank you very much, everybody.